Right. Right. Good afternoon, everyone. Welcome to our monthly webinar, Adjustment of Status from the Inside. Thank you so much for joining us, or I'm sorry, Adjustment of Status, Understanding the Green Card Process from the Inside. Um, Thank you again so much for attending. Before we get started, I just want to be sure that everyone can hear me, so that we, make sure all the technical issues are out of the way. If you can hear me, okay, great. Somebody gave me a thumbs up. Thank you so much for that. Also want to be sure that you are seeing my screen where you see the presentation. Let me know if you see that as well. Okay, perfect. Uh, Thank you so much. All right, so let's go ahead and get started. As I was saying, our webinar for this month is Adjustment of Status, Understanding the Green Card Process from the Inside, where we'll talk about what is an adjustment of status, how are you eligible for adjustment of status, what is the process, and of course, we'll discuss the recent announcement by the government about a month ago regarding the adjustment of status process. So let's go ahead and get started and let's see, make sure I'm okay, but before we do that, I do want to introduce myself again. I'm Ann Badmus with Badmus Associates. And for those of you who don't know us, we are a law firm that has helped thousands of clients gain immigration status since 1993. And we're fortunate to have been recognized in several publications as one of the best law firms in the Dallas area regarding immigration. So with that said, I also want to explain that the information that we're going to provide for you today in this webinar is really general in nature. We are unable in this forum to present any specific advice to anyone that is viewing today, mainly because everybody's situation is different. And so really for specific questions or consultation about your specific situation, you really should meet with an experienced immigration attorney. So we encourage you to do that and certainly encourage you to reach out to us if you have not already. And another guideline today, and excuse my voice for some reason, I'm having a little difficulty speaking, but hopefully you will be able to hear and understand me. But for questions and answers, we do want the opportunity to, or give you the opportunity to ask questions. So you can do that at any time during the presentation. Just be sure to put your question in writing into the chat feature of the Zoom platform. But for confidentiality, because this is pretty much a public forum, we want to make sure that you're maintaining confidentiality about your situation. So please try to ask questions in a general manner and not include personal details about your situation in this forum. I'm sorry, I'm trying to, okay, here we go. All right, so let's go ahead and talk about what we're going to talk about today, today's agenda. So what we're going to talk about is what is adjustment of status, then we'll talk about who is eligible, what is the process. We'll talk about the policy update, meaning the USCIS memo that came out around March 21st. So we'll talk about that, and then we'll discuss finally some key takeaways and action steps. And at the end, we will have time for your questions as well. So what is adjustment of status? Well, typically when anyone is applying for a green card, no matter what the qualification is, whether you're applying based on a family relationship or whether you're applying based on a job sponsorship or even applying on your own through maybe EB-2 national interest waiver or EB-1 or even EB-1 extraordinary ability, EB-1A extraordinary ability, or applying through the EB-5 immigrant investor program, no matter which way you are applying or which category you are in as far as applying for a green card, there are two pathways to ultimately obtaining that green card. Once you have qualified yourself through, as I mentioned, family relationship where you have a U.S. citizen or permanent resident relative who has filed and gotten an I-130 application approved for you, or whether you have gone through the employment-based process where typically it is an I-140 or a perm application and an I-140 submitted for you. You then have to choose which path you're going to use in order to ultimately get your green card. So there are two pathways, either depending on where you are physically, whether you're in the US or whether you're outside the US or whether you don't qualify to obtain your green card from inside the US, and you may actually have to leave the US and apply at the US Embassy. So there's really not any better path. It really depends on your circumstances and qualifications. So for adjustment of status, there is an advantage that if you are inside the US and you do qualify for adjustment of status, the process does allow you to stay in the United States throughout the entire process, even if your visa status has expired. So for example, if you have an H-1B visa that has of course, has an expiration date, and you've applied for adjustment of status, and you decide not to renew that H-1B visa, potentially you should be allowed to stay in the U.S. Based solely on the adjustment of status application, even if you have an expired visa. But again, these are depending on very specific circumstances for each individual. You can also, as part of adjustment of status, request a work permit or an EAD, employment authorization document, as it's called, and a travel document, or what is called an advanced parole document. These benefits allow you to work while you're waiting for your green card application or your adjustment of status application to be decided. They also allow you to travel internationally while waiting for your adjustment of status application to be decided. Another advantage is that there is no requirement that you leave the country and interview outside the country. Now, you may have an interview within the U.S. With the USCIS officer, but you don't have to leave the U.S. in order to interview for your green card. And of course, if you are in the U.S. with adjustment of status, ideally you should probably remain here and not have any concerns about travel. Or not leave the U.S., not be required to leave the U.S. But let's say if you do leave the U.S. and you do have the advanced parole document, which is a travel permission, or even an H-1B visa, for example, you can usually re-enter the U.S. after international travel while your case is pending. Now, the opposite, and those are just some of the benefits. We don't have the time to go through every benefit of the adjustment of status, but that generally is what you can do if you are applying through adjustment of status for your green card. The other process is what we call consular process. So this is where someone does not qualify for adjustment of status, or they are not in the United States, because green card applications can be submitted for those who are not physically in the U.S. So for example, with a relative application, if you're applying for your parent, you as a U.S. citizen applying for your parent who's outside the U.S., you can do so by filing the I-130. But if they are not in the U.S. or they're not eligible to come to the U.S. on another visa and do adjustment of status, and instead they have to process at the U.S. Embassy, they can do so by going through the consular process. That would be true also of employment-related green cards, or even EB-5 green cards where the applicant is not physically in the U.S. So what that means is that assuming that the I-130 or the I-140 or the I-526 for an EB-5, assuming that the qualifying application has been approved, then the applicant would be applying and completing the process in their home country. And sometimes that does require that if the person is in the U.S. and they cannot apply for adjustment of status, that they do have to leave the U.S. and attend the consular interview at the consulate. So you can't have a consular process without physically at some point leaving the U.S. and attending the interview at the U.S. consulate. The disadvantage to that, of course, is it is subject to backlogs for the consulate. The consulates can tend to have so many applications, and even though someone is eligible to get their green card through the consular process, it may take a very long time because there's a long queue in order to get the interviews scheduled. So there could be very, very long wait times. In addition to that, there may be, excuse me, there are, as we know, under the current Trump administration, there are a lot of directives to the consulate to not process applications. So, for example, there is a 75 country pause on consular processing for immigrant visas, as well as some other temporary visas as well. But for the immigrant visa, which is effectively the green card application, if you are in the queue for consular process for an immigrant visa, currently there is a 75 country ban. And if you're an applicant or your relative is an applicant that is from that country, even though the embassies are processing those to the extent of setting interviews and scheduling interviews and taking documents, they are not approving them until that 75 country ban has been lifted. So that, again, is a disadvantage, of course, in processing at the U.S. Embassy, because those things can happen. The reentry, also, if you are waiting in queue for the consular process, and you're trying to come into the U.S. while you're waiting for that, usually if you do have an effective visitor visa, you would be able to re-enter using that or come into the U.S. with that visa. However, if you do not have a visitor visa and you are in the process for immigrant visa, it may be very difficult for you to get a visitor visa to visit while you're waiting for your immigrant visa process, because the embassy will see that you are actually in the queue for the green card. And so that would be in contradiction to a visitor visa, which requires an intent to return back, or it could be a contradiction in their eyes as well. So long time on that slide, but basically I did want to give you some background as to those two pathways. So let's talk about putting consular processing aside. Let's now talk about adjustment of status, which is what we're here for. So adjustment of status is law under the government's the law under INA 245A. So what is INA 245A? Well, INA is the Immigration and Nationality Act, which was enacted by Congress many years ago, almost about 60 years ago. And Congress described how someone can be eligible for adjustment of status, meaning how can they go from being whatever the status they're in currently in the U.S. to getting actual permanent residence through the adjustment of status process. So the three core requirements for that was that they need to be, if you are applying for adjustment of status, you need to usually have come into the country legally through inspection, either at the airport or at the border, where the government allowed you to come in either because of a visa or you were paroled in under certain special circumstances. So you have to have a lawful entry into the U.S. Then, of course, you also have to be eligible for the green card based on the qualifying category, the immigrant category, whether it's through employment, family, diversity visa, in some cases asylum, or special immigrant, which usually there's typical different special immigrants, but the typical one we look at is the religious worker category. So you have to qualify on that basis, of course. So that has to be established. And then you also have to have a visa, immigrant visa, immediately available, meaning your priority date must be current, meaning that there is a visa based for you based on the timeline of the government. And we'll talk a little bit more about that in detail. So one thing to be mindful of that really has been emphasized, especially because of the recent policy memo that has come out from the USCIS, is that adjustment of status has always been considered a discretionary benefit, meaning that there's not an automatic or guaranteed approval of an adjustment of status application. Now, it doesn't mean that the government can arbitrarily, for whatever reason, decide not to approve you for a green card or adjustment of status if you otherwise qualify. However, it is still somewhat not an entitlement or not a requirement in most cases for adjustment of status. Now, typically, that has not really been something to be concerned about, this discretionary benefit language or policy, because usually the government has approved if you have met all of the qualifications that are laid out in the law. But as we'll talk about later, the government has kind of thrown in sort of a wrench into and using the discretionary benefit to kind of give them more, I guess, authority to not approve an application that might otherwise be approvable. So why adjust inside the US? Well, of course, as we talked about, you don't have to leave the US. You can remain here, especially if you've established strong ties through being here on an H-1B or other visa as well. So you don't have to have an interview abroad. Everything will be done in the US. You will be able to obtain some work authorization while waiting for your green card if you don't already have work authorization. And then there's not a risk of leaving and not being able to come back if you're in adjustment of status. So the risk is very, very low. So that being said, who is eligible? Because not everyone, even those who are already in the United States, not everyone is eligible. So just being in the US does not make you eligible for adjustment of status. We have to look at various requirements, legal requirements to determine whether or not you are able to actually apply for adjustment of status, assuming you're qualified otherwise for the green card. So as I've talked about somewhat, you have to, of course, meet those eligibility categories. So these are just laid out to you. Again, I won't spend too much time, but again, family, employment-based, diversity visa, asylum and refugee, those who have received asylum can, or refugee status can eventually apply for green card adjustment of status, and then special immigrant visas, which are rare, but certain categories, especially religious workers, can do that. So what you must realize that even if you have an approved application I-130, I-140, or I-526 through the EB-5 process, it doesn't necessarily mean that you are immediately eligible to file adjustment of status. First of all, you must determine whether an immigrant visa is immediately available. So how do we do that? Well, as many of you probably know, we have to consider or actually monitor the visa bulletin, which tells us when an applicant for a green card can actually file for adjustment of status and when they can actually be approved for adjustment of status. It also covers consular process, but we won't really discuss that here. We're really focusing on the adjustment of status process. Key thing to remember for those of you who know about the visa bulletin or have been following it already, the key thing to know about it is that the visa bulletin is published monthly by the Department of State, which is actually the agency that really governs the embassies outside the US that do consular process. However, it is also the publication is applicable to the Department of Homeland Security, which is the organization that is actually receiving adjustment of status applications. Now, some categories do not need to be concerned with the visa bulletin. In particular, the immediate relatives of US citizens are not subject to limited visas. Therefore, the visa bulletin is not even a consideration because for those who are immediate relatives, visas are always available. It is unlimited in terms of the number of immigrant visas, green cards available to immediate relatives of US citizens. So immediate relatives, just to clarify, are those who are your immediate relative if you are a spouse of a US citizen, if you are a child under the age of 21 of a US citizen, and you are a parent of a US citizen who is over the age of 21, that US citizen being over the age of 21 or 21 or older, that can sponsor you for the green card. So that category, we do not need to be concerned, but all other family preference and employment categories are subject to limited numbers of green cards. So because Congress said many, many years ago, we're only going to allow 140,000, for example, green cards available for employment-based and a certain number available for family-based. that means, that not everybody can get a green card if there are a large numbers of applicants that exceed that limit that Congress has set. So as a result, that's why we're seeing these backlogs for many that can be decades long as well. And it's also based on country of birth, because Congress also said we are going to allocate these 140,000 visas equally among all the countries of the world, which are over 100 some countries. And so some countries that have a fewer number of people immigrating are not, are able to get a faster green card, whereas those who are larger countries like China and India, which are huge countries that have more people immigrating, face backlogs of many, many years. Mexico as well, and in the family category in particular. So what you have to know when you are looking at the visa bulletin is you want to be sure that you understand what your priority date, that establishes your place in line. So the priority date is usually the date that your I-130, if it's a family application, or the I-140, if it's an employment-based application, was filed. So you have to be cognizant of that, knowing that date, and then compare that date against the visa bulletin chart. So the visa bulletin link is here. I'm not sure if I can actually link over to there, whether you'll be able to see it. But definitely you can look at the chart there. I just want to kind of give you an idea of what it means there. So if you're reading the chart, the visa bulletin chart, whether it's in the family or employment-based category, you will note that you will sometimes see the category, the notation of C. C meaning that is current, meaning there's no backlog, there's plenty of visas available. So you can, if otherwise eligible, proceed with adjustment of status. If there is a particular date in that category that you are under, then your priority date must be earlier than that date, or what we call the cutoff date. So if the cutoff date is June 25th, 2026 in your category, then you must have a priority date that's earlier than June 25th, 2026 in order to apply for adjustment of status. Now, if we have, which we have seen, if you see something like an U, which is actually going on right now in the July visa bulletin, where certain categories for India are considered U, basically means there are no numbers available. Basically, they're all used up. So for this year, for this fiscal year, which ends in September this year, September 30th, 2026, there appears to be no visas available if you see that U category, which means it's kind of an unknown timeline. Most of it's unknown, but it's very, very unknown if you see a U in that visa bulletin. So finally, just to finally clarify the visa bulletin as well, there are two charts, and sometimes they can be confusing. So you have to make sure you understand which chart is applicable for adjustment of status. So you have a dates for filing chart, which basically usually is a little bit faster, or has dates that are earlier or later, and allows you to file adjustment of status perhaps earlier than the final action chart. But let's talk about dates for filing. So the dates for filing chart, as I said, usually is a better chart in terms of speed for someone to be able to at least apply for adjustment of status. Now, the USCIS really determines whether they will use the dates for filing chart or the final action chart in order to let people file for adjustment of status. Typically, or at least the pattern has been that they'll use dates for filing, usually in September and October, and maybe even through March or February or March. They'll use dates for filing, which is really advantageous in most times because it is faster. Now, that just means that you can file your application for adjustment of status. It doesn't mean that it's immediately approvable, because you now have to look at the final action date, which does tell the USCIS when they can actually issue a green card to someone who has a priority date that is eligible. So while you may be able to file dates for filing and your priority date is good for that, it may not be good for final action. So you have to look at both charts to determine the timeline for you to actually receive your green card. Also know that with dates for filing, again, USCIS usually uses dates for filing sometime in the fall and maybe into early spring. However, usually they change to final action dates, which they did, I believe, in May. April or May, they changed to final action dates. So now the dates for filing really isn't very helpful for those who are applying for adjustment of status. It doesn't really mean anything at this point. Right now, we're having to look at final action dates. So you always want to check both charts and also check whether the USCIS, which chart the USCIS is using. Okay, so also country of birth, as I mentioned, so country of birth is absolutely important. So those who are born in certain countries, even if you're a citizen of a different country, it does make a difference there. So someone who is in the EB2 category, who's born in Canada, usually can get a green card faster than someone who's in the EB2 category who was born in India, even if you are an a Canadian citizen. If you were born in India, you still cannot, unfortunately, jump over to the queue for those born in Canada. Now, there is something I don't have mentioned here, but if you have a spouse who is born in a different country, sometimes you can use that as what's called cross-chargeability. So, for example, if you were born in India, but your spouse is born in Canada, and they also are immigrating with you, even if they're not the primary applicant, but they're the dependent applicant, you can use their country of birth and jump over to the faster queue because of that cross-chargeability. But in any event, it's very important for whatever category, whatever country of birth that you check every month for the visa bulletin to know whether or not you're eligible to file adjustment of status, but also to know whether you're eligible to receive your green card if your final action date is current. But keep in mind that the visa bulletin, although published monthly, it doesn't move forward every month. The dates do not move forward. Sometimes they go backwards, or what we call retrogress. So even though you are in the adjustment of status process and it looks like you were almost being able to approve because the final action date you were close to the final action date, the next month could show that you're even farther away because the dates have retrogressed. So that's why it's important to continue to monitor the visa bulletin, even though you have already applied for adjustment of status. And that also keeps you understanding of the timeline, because even though you're in process, it doesn't mean that the government can approve your adjustment of status application despite the priority date being later or earlier, whatever there. So now let's talk about actual eligibility. Aside from the priority dates and the visa bulletin, what are the requirements for applying for adjustment of status based on the individual's circumstances in the US? So as I mentioned before, you must be inspected or you must have entered legally into the US. So that's number one. So whenever we're looking at clients and determining whether they can apply for adjustment of status, we need to know, how did you come into the US? Did you come in with a visa? Certain visas do not allow adjustment of status either. So we have to look specifically at your type of visa. Most of them do, but we do have to look at that. So we have to look at how you entered. We also have to understand whether or not you kept legal status all continuously. Because sometimes in certain circumstances, so for example, if you are applying based on employment, then you do need to show that you've maintained lawful status since your last entry consistently without any violations of your status or without any breaks in your status, except for, in some cases, there can be what's called a 245K exception, where if your violations or your break in status was no more than 6 months since your last entry, you may still be able to apply for adjustment of status. But it's very important, again, to look at that carefully to determine whether or not you can actually apply. Then, of course, the visa number has to be available. So priority date is there. And then most important, very importantly, is no inadmissibility grounds. That meaning that there's no significant criminal history, again, immigration violations, other kinds of inadmissibility grounds that they may have. For example, for doctors, if you are on a J1 waiver, you are not admissible to do adjustment of status until you've completed your waiver. So if you apply before you've completed your J1 waiver, requirements, and basically your application, your application will be denied because you were not really admissible to do so. So those are kind of things you want to be sure that you don't have any issues that would be considered causing you to be inadmissible. And also inadmissible meaning you cannot be approved for adjustment of status. So some of the things that, again, would kind of catch people off guard if they don't understand the requirements for adjustment of status is things like, of course, as I mentioned, failure to maintain legal status throughout your entire time in the U.S. or entire time since your last entry. Unauthorized employment, working without authorization on a visitor visa or some other student visa where you didn't have an OPT, EAD, that sort of thing. So that could be considered. If you entered without any permission, so let's say you crossed the border without being allowed to come in, and so that's what's called entry without inspection. So that makes it exceptionally hard, in fact, nearly impossible to apply for adjustment of status. There are some narrow exceptions, but not enough time to go into that. If you have been previously deported, removed, that's going to be you will not be able to adjust status in most cases. If you do not have a J-1 waiver that's required in order to apply for adjustment of status, then you're not going to be able to apply for adjustment of status. We also have, there is one sort of exception to some of these bars, which is called the 245I. It is grandfathering. This is for people who had an application submitted, at least an I-130 or an I-140 or a perm labor certification application submitted on their behalf, or if their parent, if they were a child and their parent had such an application before April 30th, 2001, there might be grandfathering, which would allow them to actually do adjustment of status, even though they've not maintained legal status as well. So again, not enough time to go into all the distinctions there. One last point I want to make with respect to the lawful status when filing. I mentioned here there's some exceptions. The key exception I wanted to remind everyone is for those who are immediate relatives. So if you are an immediate relative, meaning that you're a U.S. spouse, child under age 21, or a parent of a U.S. citizen, and you did come in lawfully, but you did let your visitor stay expire, for example, or your student status, you maintained student status, but failed to maintain it and did not get any other legal status, you can still apply for adjustment of status, even though you do not meet the basic requirement. It's sort of an exception to that rule that you have to maintain lawful status when filing as well. All right, so let's now talk about the I-485 process and what to expect in most cases. So typically, if you have an I-48, if you're eligible for I-485, then you're going to need these basic applications within the package that you submit. Of course, the I-485 form, the I-864 affidavit of support if you are being sponsored by a family member. Now, when I say sponsored by, I don't mean those who are dependent applicants on an employment-based application. When I speak about family sponsorship, that means an I-130 petition, not an I-140 application. So if you are the beneficiary of an I-130 application and applying for adjustment of status, then your family relative, U.S. citizen relative or permanent resident relative has to complete the Form I-864 affidavit of support to show that there is sufficient minimum income to support the U.S. citizen as well as support you as part of their family. Then we have civil documents that are required, usually a birth certificate. This is some birth certificate, marriage certificate, if it's applicable to the situation. Your immigration information to show your immigration history. Try to have all your passport copies that you've used since you came to the U.S., all of your visas, I-20s, DS-2019s, whatever immigration documents you were submitted, approval notices, all those things you want to be sure you have kept a good record of all of those things. And your I-94, those are very important as well. Photos, and filing fees. Photos usually for now we kind of had a directive that they don't need photos, but we're being a little cautious because we are still seeing them say they want photos. So photos, what I mean is passport photos that they use to to prepare the green card, as well as EAD applications or even advanced parole cards. So you want to make sure you may be asked to provide passport photos, and of course the filing fees related to the applications. You also will have to get a medical exam. There's only kind of one exception to that, and that is for those physicians who are applying for their adjustment of status based on the physician national interest waiver. They do not have to provide a medical exam until after they've completed their 5-year, or close to the time when they've completed their 5-year medical service requirement. If you've already completed your 5-year medical service requirement, then it is a good idea to go ahead and submit that medical exam. But if you're just starting on that process, you don't have to submit a medical exam for that. Then, of course, there's optional, as we talked about, optional benefits that you can apply for an additional fee. You can apply for the work permit through the I-765 application, and then the I-131 advanced parole, which is the travel permission. Now, you would want to talk with your attorney to determine whether or not it's even a good idea to apply for at least the travel permission. We usually recommend, especially now, that you should, unless you feel like you will have urgent travel or some travel needs for business or something like that, it's probably better not to travel while you're waiting for adjustment of status. But if you feel like you want to have that as a backup in case you need to travel, then you should apply for that. But keep in mind, they are only issuing 1-year EADs and 1-year advanced parole documents, which means that you have to use those documents within that 1-year period, and then renew if you want to continue. If you haven't gotten your green card and you still want to renew those documents, they have to be renewed yearly. As I mentioned, with travel, you have to have advanced parole if you are planning to travel, unless you have a H-1B or an L-1 visa. Otherwise, if you don't have one of those 2 types of visas, then if you leave the U.S. without having advanced parole issued to you, you are considered to have abandoned your application, and you will not be permitted to return, even if you have a unexpired visitor visa or an O1 unexpired visa or some other type of unexpired visa. Usually they would not allow you to return back, but certainly they would also deny your green card application because you left without that advanced parole permission. And then the final point about filing the I-485 is concurrent filing. So we talked about being sure that you have an I-130 or an I-140 approved. But in some cases, if your priority date is eligible, meaning that it's current, you're able to, let's say for right now, for EB2 category, for the rest of the world, it is now current, which means that even if you haven't established a priority date, you can apply for your adjustment of status and establish your priority date by filing your I-140 and your I-485 at the same time. Okay, now, if you do that, it can save you time. However, know that you need to be pretty confident that your I-140 will have a great chance of approval, because if your I-140 ultimately is not approved and it is denied, then your I-485 will also be denied, and then you would have spent that money for everything, and then would have to start over again. So you want to be careful about concurrent filing. But in most cases, for example, an immediate relative petition where someone just got married to a U.S. citizen, you can file an I-130 and an I-485 at the same time. That is a typical practice to do so. Let me check here. I see someone writing something here, so let me see if there's any questions that have come up here. Let's see. If you have any questions, like I mentioned, be sure to put them into the chat as well. I don't see anything so far. So now, after filing, what happens? After you file, typically you will get a receipt notice, which will document that you have filed for every application that you filed for adjustment of status. So if you filed I-485, well, you would have filed an I-485, you will get an I-485 receipt notice. If you filed I-765, which is for your EAD, you will get a separate receipt notice for that. And then if you also applied for advanced parole, you will get a separate receipt notice for that. So those three applications, if you applied for all three of them, you will receive a separate receipt notice, and that's how you can track your case online. They will also usually send you, if you don't already have a USCIS account, online account number, they'll usually send a notice that will tell you how to obtain or create your account. And if you create your account, that according to that notice, you should be able to see all of your receipts under that account as well. And any updates that happen in your case should be shown on there as well. Now, it's not a perfect system, so having your case online, just because there is a notice or a notification on that online, or if there's no notification, doesn't mean there's anything going on with your case that's wrong with your case or negative or anything like that. It is just a complementary system that they provide to allow you to track things, but it does not control what's going on behind the scenes at all. So keep that in mind as well. And then, for example, if you do receive, and I'm just going to talk a little bit more about that online system, if you do receive a notification online that there is an RFE, for example, that they've mailed out. Now, they will mail it out, and sometimes they will upload it into that system, sometimes they won't. But if they say they mailed it out today, don't expect that you will have it today. It will have to be mailed, go through the mail system to know what's on there. And when they notify you that a request for evidence has been sent out, there's nothing else to tell us what it means. Like, what are they asking for? So you will not know what they're asking for until you actually receive that request for evidence as well. So keep that in mind as well. So after the receipt notice, usually there will be a biometrics notice that you receive, typically a month after or so. And what that is saying is that you are now needing to go and get your fingerprints and photos taken at your local application service center. They will give you the address, and you need to do that and make sure that you do attend that. If you cannot attend that appointment, you want to make sure you notify them to request a different date, or sometimes you can do what's called a walk-in if you think you can go earlier than the appointment date. Sometimes they will admit you as long as you bring the notice, and if they have enough time to do it, they might do it. They don't have to, but that's another option in case you can't make the date that they have given you. Next, you have the RFE, which there's not always an RFE. Sometimes there is. RFE just means that they need more information. And so if you do receive an RFE, of course, you want to make sure that you know what the deadline is and you respond fully and within that deadline. I normally recommend take your time to look at the RFE, even though when we get an RFE, we want to just get back to it, and we think we're going to get a decision right away. Getting an RFE and responding to it doesn't mean that they're going to approve your application within any time frame at all, honestly. They do say you can follow up with them if it's like 60 days or more, but that really depends on the type of application it is. But for an adjustment application, even if you got an RFE 2 months afterwards and they ask for something like, a birth certificate, which they thought may need some they may need a different birth certificate or something like that. Just because you respond back doesn't mean they're ready to apply for or ready to approve your application. It just means that someone at the government has just gone through just vetting your application, making sure they have everything. Then they will put it on the desk or put it in the queue for decision. And that queue could be way longer than what you expect, because right now the government is typically saying it can be anywhere from most of them are saying at least 2 years, basically, but usually you will see people getting it faster than that. You'll see people getting it longer than that. Unfortunately, the government does not treat these applications as a strict line. So because there's many people looking at these applications. Some officers may be faster than others. There may be certain service centers or certain locations that are faster than others. So there is nothing that really says, okay, this is a specific timeline that you that the government is required to process your application. Now, they cannot, take 10 years or anything like that, but keep in mind that this is not typically a very quick process as well. Then finally, I will just last 2 points here with the interview. Usually in family-based cases, there's always an interview at the local immigration office where the applicant is. So if you are the green card applicant, usually it will be at the closest immigration office to you, and usually your family member who is sponsoring you, well, particularly the marriage, if it's marriage-based, the spouse always has to attend. For relatives, like if you're applying for a parent, usually the U.S. citizen who is applying for their parent doesn't normally have to attend, but it just depends on the circumstances. But in most cases, if it is a marriage-based application, both parties have to attend, and usually 100% of almost 100% of the time, you will have an interview in that circumstance. Other family cases may not necessarily have an interview, like a parent case or a child case may not require an interview. For employment-based cases, for the longest time when I was practicing, there was almost never an interview for employment-based cases. That changed quite a bit under the first Trump administration, where they were interviewing everyone. And then under the Biden administration, they stopped doing that. And in fact, because of COVID, they stopped interviewing even family cases, or slowed down the number of family cases that they would interview. But now we are back under the Trump administration, seeing more and more employment-based cases being interviewed as well. So that could be something that we are seeing them approve without interview as well, but that could happen. And that would certainly be a situation where you would just need to appear and, of course, be prepared for the interview itself. We don't have time to talk about the specifics of the interview, but it is usually the purpose of just verifying a lot of the information that is verifying the information that is in your adjustment of status application, and verifying any other information that the government may have found through their background checks or anything like that. Then finally, either after the interview, if there is one, or after the amount of time that the government needs to take in order to decide your application, you will either get an approval, which means you get your green card. So if your I-485 is approved, your green card is issued, and you usually receive that a few days afterwards. But a few weeks afterwards, but the date of the I-485 approval is the date that you are a permanent resident, regardless of whether you receive the card in the mail. If it's denied, then usually the government will lay out why they denied your application. There can be a motion to reopen. You could there's really not an appeal of an I-485 application, but we may, because of the new policies or the policy announcements that we see, we may see more and more applications being actually pursued in terms of lawsuits. That's a potential possibility. Very few people have ever done that, but depending on the types of decisions, if they're making decisions that really do not seem to be compliant with the law, where they're denying you with not any real basis in law, that might be something to consider as well. Finally, the last point, when we talk about the medical exam, currently, at least right now, the policy is that if your medical exam is after November 1st, completed after November 1st, I think it's 2023, then it's sort of an indefinitely valid. However, that can change at any time. We've seen them sometimes come back and say, okay, it's only valid for 2 years from the time. So we always want to check to be sure if your case is taking 2 years or so. We have to see what the policy is at that time to see if you need to get a new medical exam. But normally you don't just want to do a new medical exam without at least getting an RFE, because we don't even know that they would accept a new medical exam or tie it to your case appropriately. So if there is a need for a new medical exam, we would wait for an RFE for that to be done. Oh, I'm sorry, let me see. Okay. So I kind of spoke earlier than that. So if we have, again, approval, the green card is issued. Sometimes if you are in conditional circumstances, conditional applications, like if you're married under 2 years at the time you get your green card, then you'll get a 2-year green card. If you're in an EB-5 program, you'll get a 2-year green card. And then later on, you'll have to file another application to make the green card permanent. If it's denied, again, they will state the reasons for the denial. you may be able to do a motion to reopen, or you may be able to file a lawsuit in court. But again, lawsuits are just like any other lawsuit. There's no guarantee of what the court will do. We just have to look at trying to make the best case before a court to overturn the government's decision. And then finally, in regards to citizenship, if once you get your green card, then for most people, it's 5 years for you to be eligible for citizenship, 5 years from the date you receive your green card. For others, when you receive your green card, or if you have been married to a U.S. citizen for 3 years at the time you receive your green card, then you will be, well, at the time you receive your green card, if you're married to a U.S. citizen and you remain married to that U.S. citizen for the next 3 years, then you will be eligible to apply for the green citizenship under the 3-year rule, as opposed to the 5-year rule. And of course, when you apply for citizenship, you file naturalization form N-400. Okay, finally, I kind of went a little bit over. Let's talk about the policy memo, because I know a lot of people are concerned with that. We've got a lot of questions on that. And so that policy memo that came out, it says is effective immediately for all pending and future applications. But keep in mind that the law itself did not change. And that's important because we have to see if the government is actually complying with the law. It's not only the lawyers and not only you as applicants have to comply with the law, the government has to comply with the law as well. So we have to verify and see how they do things. If they are doing what we would call ultra virus, which means they are going above the law or not complying with the law, that may be where the courts have to come in. But in any event, what the memo has said, and again, it's only a month out, we're seeing some things, but not a lot, and they're still not clear themselves on the directives or how they'll do things. But that memo basically told immigration officers who are deciding these cases that adjustment of status is not the preferred path for someone to apply to get their green card, that this is an extraordinary relief, although Congress never really said that. So that's one area we think that they're already going above the law that Congress created. So they're basically saying that, they're giving themselves a lot of discretion. They're using that discretionary language to say we can pretty much, use all different types of things that we think are important to disqualify someone for adjustment of status. And they're basically trying to honestly scare people into saying, you should be going for consular processing as opposed to adjustment of status, even if you're in the United States and you otherwise qualify. Well, the law has not changed. Again, the law still allows you to qualify for adjustment of status, and it does not require you to go with consular processing. If you prefer to go or choose to go with adjustment of status, you can do so. But it directs the officers to look at the circumstances, look at your record, look at your immigration record, look at your criminal history if you have any, look at your family circumstances to determine whether they should approve you for adjustment of status, even though you may qualify otherwise. And so you must, what they're saying is you must prove that you merit getting adjustment of status. Again, there's some questions about how they're doing this. We've seen some inconsistency between different offices and different immigration locations. But what I I want to emphasize is that, again, you are still eligible. If you're eligible for adjustment status, then you can still apply. It does not ban new I-485 applications. They continue to accept them. And there's no definition of what they consider extraordinary. So we have to look at each case by case. It's important for you to talk with your lawyer and look at each case, look at your case to see if there is anything. Most cases that at least we've processed, we feel like they are very straightforward cases. There are certainly good support for applying for adjustment of status. But even so, we've not really seen a lot of questions, even at interviews, about why someone applied for adjustment status. So we've even heard, at least in the Dallas office, that they're kind of backing off from doing that until they get more clarification as to what what they're supposed to do, what the officers are supposed to do, but basically they have been approving green card applications. So it's not a ban on adjustment of status as sometimes it seems to be. But those who are probably most effective would be those who did come in using these non-immigrant intent visas like student visas, visitor visas, especially if you immediately, or not immediately, but very close in time, started to apply for adjustment of status. So we have to look at that. If you have any overstays and violations, even though you might still be eligible for adjustment of status, they could potentially, according to the memo, still not approve you because you have had those violations, even though under the law, you still could be approved. And then they are also looking at countries that have already been, so if you are from one of the countries, a 75 country immigrant visa country pause, that might be an issue as well. So adjustment of status really probably is the best alternative for you because you can't really wait forever like the government seems to want us to do for the immigrant visa process. If you are an H-1B, L-1, or some of the other visas where you could have dual intent and your records are clean, it's very, not that they're saying they won't have any questions, but it's unlikely that you'll be questioned. If you're an immediate relative that has strong US ties and really no adverse history like criminal record or overstays, things like that. And if consular processing is just really not an option for you, then you might be in a better position. But again, this is only a month out, so it's really hard to tell what the government will do, but we're keeping monitoring that. So what you can do though is if you do have those gaps, overstays, unauthorized work, we want to probably prepare for that, whether it's for an interview or whether it's for an RFE. If your application's already been filed, you want to think about those things and look at your record to see if there's going to be any issues like that. Think about what the positive aspects of your life is in the U.S. Your family ties. You've been working here. You've paid your taxes. Just document all of those, even though it's a clean record, and they may not be looking at that so appropriately. And then we also want to just check, like I said, month out. So there's going to be challenges to this memo. We may even see that it be withdrawn. There could be many things that are happening. So right now we just have to take it day by day as we hear more about what the government's doing, if there's any litigation going on. So final things to remember, and then we'll go to questions. I'm sorry I ran a little bit over, but we can stay a little longer if you want. We can monitor the visa bulletin. You want to be sure you're monitoring the visa bulletin monthly, just to see where you are in terms of the queue. Make sure that you understand whether you qualify or not, whether there's any issues that might require that you not be able to apply for adjustment of status. If you are able, you make sure that if you feel like there's a need to travel or could be a need to travel over the next year or so, you want to apply for the work in itself. You can apply for the EAD, but advanced parole is something you might consider for that if there's a need for travel. Prepare or be mindful that you could have an interview coming up. And if an interview comes up, make sure you're prepared for it. So if you do have an I-485 pending, look at your record, make sure you have some positive ties to the U.S. and things that you've done if you're already since you're in the U.S. to show that you have a clean, good record and you can make good contributions to the U.S. And then we have some questions like, well, should we just do consular processing? Well, it's not automatically safer. It will take longer, definitely, but we want to look at it on a case-by-case basis. So don't just assume that that's the best path to take because of this memo. All right, so now we are having some time for questions. Let me see if there's any that's there. I actually don't see any questions. I know it was quite a long review, but go ahead and put questions in the chat. I did have, and I'm not sure if anyone can see it, I do have a copy of the PDF of the slides in the chat. So if you check the chat, if you do see the webinar slides. You can download them from there. If you don't see it, let me know. Just say no that you don't see the webinar slide and I will upload it again. Any questions? Okay. Seeing no questions, I want to thank everyone for attending today. Hopefully this has been helpful. If you do have any questions that come up in your particular circumstances, feel free to reach out to us. As you can see on our slide, there's some ways where you can schedule a consultation or give us a call to schedule. And be sure to join our mailing list for future webinars and updates, and also visit our social media. If you Google Badmus, and it's not Google, but if you go to YouTube, Badmus Associates, we do post these webinars on our YouTube channel, and we'll also send you that information. Okay, so I see that you don't see the webinar slides. I think I had them up too early, so I will go ahead and upload it now. And let me know if you can see it now. Can you see it now? Yes. Okay. So I'll stay in a minute. So someone has a question. If you could ask your question, that'll be the question we take. You need to write it in the chat, please. If you want to ask the questions here at this forum. Okay. So please go ahead and take the slides. If you're not getting the recorded webinars, go to our YouTube page, but I will send it information out. But I did have a question at one point, is the advanced parole required? Well, it's required if you're planning to travel outside the US. I mean, if you need to leave the United States, you need to have the advanced parole before you leave. If you are in adjustment of status process, if you are still waiting for your green card to be approved through adjustment of status, and you do not have an H-1B visa stamp or an L-1 visa stamp or H-4, an L-2, which are the spouse or dependents, then you have to have an advanced parole. Otherwise, you would have abandoned your application. Now, the question is it after? It's only during the I-485 process. And I-140 only establishes your eligibility. It does not have anything to do with your legal status or that approval of the green card itself. So I do see some questions popping up here, so I'll do my best. It says, can it give us a list of the questions asked in the interview? I can probably point you to some generic questions. I cannot say every question that's going to be asked in interview, but we can certainly provide just sort of the typical questions that be asked. The officers have leeway to ask nearly any question they like, and we've seen various types of questions being asked. And it depends on the type of case it is as well. The question is it better to file green card for my parents now or wait until the rules get clarified? I think that would be something to discuss in a consultation, because we don't know. I would need to know more about what your goals are for your parents, where they are, what's going on with, their immigration, whether they have visitor visas. There's a lot of questions to know. So I would need to really consult with you. So feel free to reach out to schedule a time so we can discuss specifically regarding your parents. Another question is, can someone file for both the I-130 concurrently, I-485 concurrently for a son filing for his dad? His dad has a pending VAWA. Well, yes. I mean, if you have an I-130, if your son is a immediate relative and you did come in legally, then you can apply. He can apply for you concurrently as well. Then that's just a general question again. So a general answer as well, because I did say that the dad has a VAWA case pending. If the question is whether you can have more than one application, yes, you can have more than one application for adjustment of status as well. How long does it take for a parent to receive green card if we concurrently file now? Parents are in the US. It depends. It depends on where you are. Like I said, for adjustment of status, it's the same, whether it's a parent or whether it is a spouse in most cases, or, usually they'll say adjustment of status usually is about at least a year. It could take longer as well. unfortunately, we don't have, there's no guaranteed timeline. The government just tells us that, we have cases anywhere that we've approved in 1 month, and we have cases that we've taken 18 months or 24 months to approve. I would say so we don't really know what's kind of in the middle there, so it's hard to say. I would just say based on our experience, I usually would say at least a year that it would take. Another question is, thank you for your great information. You're welcome. Thank you. Would you recommend the